because a sale of a program did not go as planned. In the SEC vs. Ripple case, the Securities and Exchange Commission is appealing the judge's ruling. It would make people like you and me very happy if we couldn't buy and sell XRP on platforms. They would be happy with how things were going. That being said, they would not have been happy if it had come out that XRP was a guarantee. But there is a good chance that this will be better for Ripple in the long run. At the very least, Ripple has a good chance of getting a few more victories. It had been a little more than 4.5 hours since the video was taken, but it had only been released 12 hours before. 3 lawyers, Jeremy Hogan, Bill Morgan, and Stuart Alderati, who is the chief legal officer of Ripple, have given their thoughts on the situation from their own points of view. Hogan thinks the SEC has a good chance of winning its case, but he also thinks Ripple has a good chance of winning some more cases that help them. Because it is now after midnight in the year 2024, the video came out on Friday, September 25th, 2024. The things that Brad Garlinghouse and Stuart Alder said about the case came from Fox Business reporter Eleanor Terrett. These comments showed that the person was sure they could win the Ripple race in the Second Circuit. They were thrilled with their case at the district level, and even more so with their case in the Second Circuit. Alabama said there were several reasons for this, and they were very happy with both situations. Al also says that the Second Circuit has a long history of not liking the Securities and Exchange Commission and legislative overreach. If you lose, there is a 10% chance or less that the Second Circuit will rule against you. It looks like the Securities and Exchange Commission will agree with Alata, which could go against what the agency wants and help Ripple while also making the law stronger for all Bitcoin assets in the US. The Securities and Exchange Commission has to decide if they want to take this case all the way to the Supreme Court, where they think they will lose again. When people at Garlinghouse were asked if they thought the Supreme Court would hear the case, they said they were sure they were following the law and the right side of history. He said that Ripple is acting in a way that is legal and has been done in the past. Overall, the Securities and Exchange Commission CC was in a tough spot because of the SEC v. Ripple case. Ripple might have to deal with extra perks and legal issues. If the Securities and Exchange Commission decides to appeal the decision, it could get in the way of Gary Gensler's plans to regulate cryptocurrencies. Stephen Alder, an officer of Ripple, has given us Form C, which lists the reasons they want to use in their cross-appeal. Alder doesn't think the question is whether or not XRP is an investment. Instead, it is in a unique situation because it can work with Bitcoin. It is the law, so the Securities and Exchange Commission is not going to fight this decision. Since the government has never questioned Bitcoin, Alder wants to know when it became legally certain. It is well known and widely used because Judge Torres ruled in court that XRP is not a security. He believes that no government agency would specifically go after Bitcoin because of this. Alderode is interested in XRP because it has made the law clearer by recognizing Bitcoin as an investment. So he wants to know if there is anything that legally stops it from being a security. Alderode hasn't seen anything like that, but he has been closely following the case and its fallout. Would someone be able to point him in the direction of a resource that could help him? The appeals court of the Securities and Exchange Commission set a standard for the cryptocurrency industry. This means that the agency can't ask for more papers or new proof. In direct response to this, the case has become less flashy and less clear. However, the Securities and Exchange Commission may not have been acting honestly when it chose to stretch the case. This is because the agency has a history of making bad strategic decisions. Ripple's firm is always getting better because the appeal process is still going on. There are 4 main points that Ripple is arguing, according to attorney Alterity. B. If the seller has to follow mail rules. C. If the buyer can try to make money off of the seller's actions. And D. If an investment contract under Section 5 of the Securities Act of 1933 must have all the parts of a contract. C. Whether the seller has to follow mail rules. And D. If the buyer is allowed to be a buyer. Some people think that Ripple's claim that an investment contract can't exist without a contract makes sense. However, this claim is not supported by any legal authority, and to most people it has never made sense. Lawyer Hogan told Harry that Ripple has sent a notice of appeal about the need for an investment contract to be a legally binding and enforceable deal. People who bought XRP directly from Ripple were bound by legal contracts. That's why the company is bringing this case to the attention of the appeals court to help the whole cryptocurrency community. In this case, if Ripple won, it would make sure that the SEC's compliance system works perfectly. But that wouldn't keep the company from having to pay the $105 million ruling that was already made against it. There was a good reason why Hogan's lawyer said the SEC made a mistake in Judge Torres' ruling. They were too selfish to let it go, even though they knew they could. In theory, though, they might be able to fix the mistakes they made. The coin business has set a new record thanks to the Securities and Exchange Commission's appeals court. Still, it's not clear that the industry will benefit from the SEC's move to keep the case going. Not only is Ripple's company getting stronger every day, but the whole cryptocurrency market will gain from how this disagreement ends. There is a lot of disagreement about whether or not Ripple's XRP transfers are allowed. For a bond issued by the Securities and Exchange Commission, several Ripple transactions were found to meet these criteria. These include an investment of money, a joint venture, and a fair expectation of returns that come only from Ripple's work. In its case that Ripple's actions did not form a joint venture, the court looked at the evidence and came to this conclusion. The court thought this was silly and threw it out as a bad case. More thought was given by the court to the question of whether Ripple had sold XRP as an investment scheme. All of the ideas behind the Howey test were shown to be false by doing this. It's possible that Ripple will say that they would have been stronger on the other side of the case if Judge Torres had made any mistakes in her ruling. The lawyer for Ripple complained that the Securities and Exchange Commission had said different things that were meant to be confusing about how federal securities laws should be applied. The lawyer also said that it was not clear how those laws should be applied to virtual currencies and other digital assets. It put forward a factual dispute that could be taken seriously to support its claim that it did not get enough warning that the actions it took violated Section 5. People were surprised that Ripple fought back against the fair notice argument, even though no other lawyers in the area had brought this up before. The court also looked at Rule 65, which says that the federal rules of civil process do not allow an injunction. This rule says that there must be more accuracy and clarity. Although Ripple may have an order that stops them from breaking the law, the lawyer thought that Ripple was still required to follow the law.